I'm going to talk a little bit about some of the things I talked about in the earlier presentation, but more about the Andrew decision and what has happened since then. Of course, Andrew F. Is the most recent Supreme Court decision regarding a FAPE, and so I'll talk about that. It's been a very important decision for us. It's actually been not quite 5 years, but 5 sounds better than 4.5, so I title it 5 years on. But what we're going to do in this presentation is, first I'm going to talk about the ruling in a lot more detail than I did last time. Then I'm going to briefly go over a few circuit court decisions, one of which I think is really interesting and has a lot of implications for us as teachers and administrators. And then the last thing I want to do is kind of go through some lessons that I've learned, not just from these court cases, but also from what I do. And earlier I explained that I am actually a professor at the University of South Carolina in special ed, and most of my 30-some years there has been I've been working in legal issues, and not so much from a legal standpoint, but more or less what it means for us as educators. And also, I'm a state review officer, which in South Carolina, we have what's called a 2-tier hearing process. You folks used to have one, but I think you just have 1 tier now. And yeah, 1 tier, thanks for that. In a 1-tier system, what happens is if you have a dispute between school districts and parents, and it can't be solved. I know earlier session Julie was talking about her 4 C's, but if you can't solve it through communication, collaboration, you would hope it not go to a due process hearing, but if it does, that's when the school district in South Carolina will call up with every school district, and you used to do this too, every school district in South Carolina has to maintain a list of between 10 and 20 impartial hearing officers. They don't employ, but they have to have them available to be a hearing officer. And then the school district will have a hearing. Who's been in a due process hearing here? So you know what it's like. When you do it here, it's just done at the state level, at the State Department? Or is it actually done in your school district? It is. Oh, okay. Well, so that's a little different than in South Carolina. The first tier is done in the school district. So an impartial hearing officer will come in, and the parents and their attorney will be over there, and the school district and their attorney will be at that table, and there will be a witness stand and a court reporter. I mean, it's kind of like going to court. You know, some lawyers, attorneys will call you Your Honor, and you're not really Your Honor, but that's okay. So what happens is both sides will present their arguments. Both sides will cross-examine witnesses. So teachers often, I don't know what your experience was, but in most experiences, the attorneys will go into the schools, get the teachers, prepare them for testimony, prepare them for cross-examination. I mean, it's like going to court. It's not a real fun thing. But that happens at the local level in South Carolina. Now, the hearing officer this may differ by state, but generally has 30 to 45 days to render their decision. So they read the briefs from the attorneys, look at all the evidence, look at all the exhibits, and then make a decision based on the idea. So they know the law real well. They make a decision, and that's final unless either party decides to appeal. So I guess it's really not final. But if they appeal, in South Carolina, that's when it goes to the State Department. And the State Department will assign a hearing officer, a state review officer they call them, to read the decision from the local hearing officer, look at the testimony, look at the exhibits, and make a decision. Did the hearing officer perform? Did he meet the law? Did he get the facts right? And did he apply the facts to the law correctly. So that's what I do now. I don't have to sit at a school district and, yes? No, there are certain people who are designated as state review officers. Your state has not gone to administrative law judges? Many states have, where there's actually an administrative law judge will be appointed, and then they might do a labor case one week and a special ed case the next week. Yeah, well, now in your state, though, it just, after that, if a party wants to appeal, they go to court, either state or federal court, right? Yeah. That's the same. So you have the hearing, then they appeal to court. In South Carolina, we have a local hearing, then a state hearing, then an appeal to court.
And we did up until about 10 years ago.
Yeah. It's an interesting thing. Now, as a state review officer, I can call witnesses, or I can look at call witness and that kind of stuff, but generally they just give me a box of exhibits. And the last case I did, which I finished last month, I had 1,200 pages of testimony and 80 exhibits, and I just sit at the dinner table and do it. And then I look at the law.
3-4 days.
Oh, it takes, I tend to take longer than that, I think. But it probably winds up to be close to 40 hours, I guess, something like that. 46, 50 hours. But it's a long process. But then, so I do that now as the state review officer. And so a lot of what I'm going to talk about today are my experiences and just what kind of stuff I'm hearing. Because due process hearings don't have really any precedential value. I mean, they're useful on the state and to see how hearing officers are deciding. But from a court standpoint, like a circuit court has precedent value, will set precedent, and other courts in that lower jurisdiction have to follow it. Hearings are not like that, but they're interesting in that oftentimes they're the first line of cases that are going to eventually being fielded by the courts. Like Julie was talking this morning about the COVID cases. They're probably mostly at hearing now. And eventually we'll probably be getting up to courts. But so I wanted to talk about that too, and that's my experience. And another experience I've had, and I've avoided this like the plague for the last few years, for most of my career, but the last year I've tended to do some expert witness testimony in cases. That's a very interesting process too. And so that kind of informs what I'm going to talk about, and I better move back a little bit. That didn't. So that's what I'm planning to do today. And were anybody in the last session on goals? Okay, well, I'm going to kind of go over some of that again because I started out talking about Andrew just to talk about the background of goals and how important they were and progress and those sorts of things. But so I'm going to go over some of that again, but not much. But what I wanted to talk about first is the primary requirement of the idea. And if, of course, I've been around. I actually I was a teacher for 12 years, and I started teaching I think it was the year that the regulations for the old Education for All Handicapped Children Act took effect, or PL 94-142. So I've been around a fair while, and the primary requirement of the law has not changed. The primary requirement of the law is still that we confer a free, appropriate public education on the students with whom we work. The definition of free, appropriate public education has not changed in the law, not changed in the regulations. It's the same thing as Article 7, I don't think, or that one has not changed. So the definition of a free, appropriate public education is the same since, same thing as it's been since 1975. And this is the federal definition, and the definition, to my knowledge, of pretty much all states use. I mean, some may add a little bit to it. They can't subtract anything. But it's special education-related services that are provided at public expense, and of course that means what we put in the IEP, we really can't charge parents for those things. I mean, they're Medicare and things like that, but it's at public expense. The second is that it meets the standards of the state educational agency. So that's kind of an acknowledgement of the fact that the Constitution to the United States does not address education. And as the Constitution only really gives the powers in the Constitution are those that are given to the federal government. So really the federal government doesn't have the ability to control education in the sense that like a state would, where they say this is what you have to do. What they did is just what they did in PL 94-142 is essentially said, here, we have a bunch of money, and if you do what we want you to do, you submit a state plan that follows the law or follows the then Education for All Handicapped Children Act, we will pay up to 40% of your excess costs for educating youngsters with disabilities. So that's what the federal government said way back in 1975. Now, interestingly enough, the president at the time was Gerald Ford. This is a little bird walking. But Gerald Ford signed it, and when he signed it, I would have thought, you know, like the ADA would have been a Rose Garden ceremony or something that garnered some attention. In fact, he didn't sign it in any public place at all. In fact, I actually talked to someone at the Gerald Ford Library this was last year, and they said their suspicion he signed it on Air Force One going to China, just by himself. And his signing statement, like, I remember the signing statement for when George H.W. Bush signed the ADA. It was a magnificent statement. He said, I put my pen to paper, let the shameful walls of discrimination come tumbling down. Really kind of poetic. And Ford's was, I like the law, the intent of the law is good, but it's not going to work. So that wasn't really that interesting a statement, but he was actually kind of, he had a bit of foresight there, because what he was meaning is that Congress will never fund this law at 40%. They won't be able to. And he was right, they never did. The most it's ever been is like 18% funding. So it's kind of interesting. And there's a law right now, there's a law before Congress called the IDEA Full Funding Amendment Act. I think it's folded into the, not the American Rescue Plan, but whatever they're going to name the new one, to put IDEA on a glide path to reaching 40%. So I think that would make state folks really excited to actually get 40% of their funding. Well, that's totally without the, I don't know why I even said that, but includes preschool, elementary, or secondary education, and fourth is provided in conformity with the IEP. Now that is not a really good definition. It's not clear. In fact, the Supreme Court did say it wasn't clear. And when the IDEA was originally signed, one of the co-sponsors was a senator from Vermont named Robert Stafford. And the way he defined FAPE is, well, he wrote an article for the Vermont Law Review back in 1978, and I thought it was so interesting. What he said is, we never really intended FAPE to have any meaning. What we intended is to establish a baseline mechanism called the Individual Education Program that gives life to a FAPE. In other words, what Stafford said, FAPE is whatever you folks, whatever we think it is, and we put in the IEP. That is a FAPE. That is a child's individualized, free, appropriate public education. So that is the document. That is the blueprint of the FAPE. Every due process you guys have done, probably, every due process hearing I've done about FAPE always boils down to what was done at the IEP table. What was written in that IEP. And so that is our baseline mechanism. Now, almost immediately upon the Education for All Handicapped Children Act, or we used to call PL 94, being passed, there started to be hearings. Well, the hearing officers didn't have a lot to go on back then, so they'd make decisions. It'd be appealed to state or federal court. 90% go to federal court. And so the federal courts started making decisions. And one of the main issues they had with is, what is a free, appropriate public education? And they kind of had to make decisions with out of whole cloth because they didn't have any real guidance. Well, come in 1982, parents of a young girl named Amy Rowley, and that's Amy, filed an appeal with the U.S. Supreme Court. Her case had gone from the IEP table. She was a kindergarten student at Furnace Woods Elementary School in Peekskill, New York. She's profoundly deaf. Her parents were profoundly deaf. In fact, the mother was a teacher at Gallaudet University at one time. They called they assumed that Amy was going to go to their local school for the deaf and blind. Well, when this law was passed, they were very excited. When Amy got to kindergarten, she was profoundly deaf, and they were profoundly deaf. They got a hold of the principal, let her know that they wanted Amy to attend the public school, and he was very excited to have a student with disabilities. I don't know, now none of you are as old as me, but if you were, maybe Dale, maybe Matt. No, Matt's not even close. Not even close. Dale. Dale. No, you're not either. But I don't remember a lot of kids with disabilities when I was in elementary school or middle school, because they could be, the principal would say, no, we don't serve kids with disabilities here, and they could be excluded. So what happened, though, is the principal of Furnace Woods was very excited to get a student with disabilities, because, of course, they didn't have any students with disabilities. And they had gotten together kind of an IEP team, looked at all her assessment data and said, you know, we understand Amy is deaf, and they said that to her parents' interpreter, and we're so excited that she'll be here. What can we do to make this the best experience we can? Well, and they talked, and they came up with things like, we'll have a SLP, speech and language person, pathologist working with her, we'll have a tutor, we'll do this, we'll do that, we'll train teachers in sign language. I mean, they were really doing a lot for Amy. And Amy's parents said, boy, that sounds wonderful, but we want a sign language interpreter. And the principal said, well, you know, let me get back to you on that. I'm going to call my school board. And their school board attorney said, don't do that. You know, what you might want to do is try to hold that off, and we'll just see what happens. And so they said, well, while she's in kindergarten, she doesn't need it, so we won't have a sign language interpreter in the IEP. And the parents said, well, you know, as courses get more academic, as she gets older, she's going to need one, so we want one. And that's where their disagreement occurred. They could not agree on the sign language interpreter. School said no. Parents said yes. Went through due process hearing, and it went to the State Board of Education in New York, which at the time was a two-tier system, like South Carolina, and the parents decided to appeal to federal court. Well, interestingly enough, when it went to the U.S. District Court in New York, they overturned the hearing officer and the due process. The due process hearing officer and the state had both decided in favor of the school district, the Hendrick Hudson School District. And the district court overturned their position, because essentially what the district court held is that this new law, the Education for All Handicapped Children Act, requires the delivery of a free, appropriate public education, which I interpret, the judge for the district court, as equal educational opportunity and an education that allow Amy to meet her maximum potential. Well, the school district appealed to the U.S. Circuit Court of Appeals for the Second Circuit, and they affirmed the lower court decision, excuse me, that the school district had to offer equal educational opportunity and an education that allowed Amy to reach her full potential. School district appealed to the U.S. Supreme Court. Well, the U.S. Supreme Court, when they hear a case, they will consider one or two questions that the attorneys raise. So in their what's called petition for certiorari, the school district, or the parents' attorneys, who was also, by the way, profoundly deaf, wrote that essentially the decision of the lower court should be upheld, that because Amy, this new law FAPE requires that Amy receive an educational opportunity equal to those received by general ed kids, and that she meet her maximum potential. Went up to the Supreme Court. This, interestingly enough, when the Supreme Court heard Board of Education v. Rowley, it was in 1981, toward the end of 81. The decision came down in 82. I was a master's student in special ed that time, and there were people that thought, my gosh, they just might say this is an unconstitutional law and just throw it out. And then we're going to be back in the Wild West of principals doing what they want, states doing what they want. So, but they didn't do that. In a 6-3 decision, the U.S. Supreme Court ruled that the Henrik Hudson School District did prevail, that they did provide Amy with a FAPE, and this is their reasoning. One of the things Supreme Court likes to do is provide tests for lower courts and hearing officers to determine if a FAPE has been delivered. And they said, this is our FAPE test. Number one, has the school district complied with the procedures of the law? And we all know the idea is just chock full of different procedures that we have to follow. And number two is the resulting IEP reasonably calculated to enable the student to receive educational benefit? And this is the test. And we say that the Furnace Woods Elementary School, the Henrik Hudson School District, had done a bang-up job of following the procedures of the law. They were fine there. So then the Supreme Court turned to the second part of the test. Is the IEP reasonably calculated to enable Amy to receive educational benefit? And what they decided is that, well, Amy, in a footnote to the Supreme Court case, Chief Justice Rehnquist, who wrote the decision, said that Amy we're making the decision based on Amy. Amy was not your typical special ed child. She was profoundly deaf. She also had 140 IQ and was extremely academically able. Not, a typical student that we see in special ed. So they didn't have a lot to go by to determine what were these educational benefits. So what essentially they did is they said, well, she's passing from grade to grade. She's doing very well in school. So we think the IEP was reasonably calculated to provide educational benefit. Now, this test had to be used by lower court judges, due process hearing officers. You had a FAPE case, you had to use this test. I had a decision before Andrew, and I had to use this test. So that's the way every court essentially decided a FAPE. But the Supreme Court, remember, said this only applies to Amy. We're not saying this is reasonably calculated to provide educational benefit, and that means passing from grade to grade. Is for every child. It clearly works for Amy. So, but the upshot was that every time a court heard a FAPE case, this is what they had to do. Well, that first part was never too difficult for courts. Did the school district follow the procedures? You just look at the idea, look at what the school district did, kind of match to the school district's actions to the idea, and either they did or they didn't. And so that wasn't a difficult one for courts. The second one was a very difficult one for courts, because when can you decide if a student has received educational benefit? If you have a student like Amy, it's one thing, but if you have a student like most special ed kids, you have to grapple a little more with the content of the education. In fact, that's the word Julie Weatherly actually calls this the content standard, because it really has to do with what do we put in the IEP. That one was a more difficult one for courts to grapple with, and I'm sure you folk as hearing officers did FAPE cases where you had to grapple with that question too, and it's not an easy one to answer. So not just hearing officers, but courts too. This is a map, of course, of the district and appellate jurisdictions. If you look real close, you can see these little dotted lines that are the district. But the most important thing is the appellates. We have all these appellate courts in the United States. And as I've had to tell Dale a couple times, Hawaii is not down here. It's really up here, right? I'm sorry you had to say that, Dale. That's not true. But anyway, these are the different circuits. Now, of course, I live in South Carolina. You folks live up here in Indiana. We're in the 4th Circuit. You guys are in the 7th Circuit. So, you know, decisions from the circuit courts are obviously quite important, and they can have great persuasive value, but you're generally, it doesn't have controlling. What happens in the 4th Circuit doesn't have controlling authority in the 7th Circuit. But, so we had a funny situation arise with the second part of the test. We had a lot of differences. We had some jurisdictions, like the 3rd Circuit, the 6th Circuit, the 5th Circuit, and sometimes the 9th Circuit, who said, well, Congress would not have passed this law to provide just a little bit of educational benefit. They must have, they passed this law to provide meaningful benefit. And so they kind of developed a higher standard for the second part of the test. So if we look back at the test, the 3rd, 5th, and 6th Circuit had a higher standard. The other circuits, however, had interpreted that second prong of the Rowley test to be lower. So the 10th, 7th, 8th, of course you guys in the 7th, I was in Minnesota in the 8th, 2nd, the 4th, the 11th, they really kind of had a lower standard. So a school, what this meant is effectively a school district had to meet, if you were in the 3rd Circuit, you really might have a hearing officer applying this higher standard to your school district. And if you're in the 10th Circuit, you might have a low standard. So we had a little difference between the circuits. And then we had one, the 9th, that was confused. Circuits have 12 judges on each circuit. They tend to, they divide them into groups of 3. And we had some groups of 3 using the meaningful benefit standard and other using the lower benefit standard. So the 9th Circuit was kind of confused. Well, anytime you have this kind of situation among the circuits, it makes it more likely that the Supreme Court may step in and try to settle this difference. And there was a case that occurred right in Colorado, actually, right in the middle of the state in Denver, about a young boy named Andrew, and we don't know his last name, he's just called Andrew F. by the courts. He was called Drew by his parents. He was a student at Summit View Elementary, and this is a picture taken by my friend and fellow presenter here, David Bateman. If he went far enough back, you'd almost see the Denver in the background, the bigger buildings in Denver. So it was right out of Denver. He was a 4th grade student. Drew, as his parents called him, was a 4th grade student. He had autism. He was more of a typical child with a disability than was Amy Rowley, certainly. And he had behavior problems, and he had difficult time academically. And he had been at Summit View Elementary since he was in preschool, kindergarten, 1st grade, 2nd grade, 3rd grade. In 4th grade, the parents started noticing that Drew was starting to have more problem behaviors, that his academic progress had seemed to stall. And so they went to the school district and they said, we need a new IEP that addresses Drew's needs, and maybe I think we need to do more behavioral programming. We'd like you to do a functional behavioral assessment on which to base his behavioral programming. And the school responded by doing an IEP that was essentially the same as the years before. In fact, some of the goals were lifted verbatim from the IEP. So what the parents did is they went and they pulled Drew and put him in a local private school called Firefly Autism House. And this picture was also taken by David. If he had pulled back a little bit, you'd see Firefly Autism House. It looked like a house you might see in a suburb someplace. It was a small little facility, but they employed some pretty highly trained BCBAs as teachers. They had an ABA person on staff. They wrote essentially their own kind of IEP. And Drew did very well in 4th grade there. He did well enough that his behaviors were getting under control. His parents felt as academically he was doing better. And so they decided to go back to Summit View because they wanted Drew to be educated in a public school if possible. And they talked with the folks and said, let's develop a new IEP. The school district's IEP looked the same as the old IEP. There was very little behavioral programming. Of course, there was a dispute about that. The school said, yes, we have it. The parents said, no, you do not. They didn't do a functional behavioral assessment. And academically, some of the goals were the same goals as in the past. Well, they decided to keep Drew there. And they went back and they later sued the school district for tuition reimbursement. And I'm sure you guys have heard tuition reimbursement cases. You have to, the hearing officer or the judge has to decide, number one, did the school offer FAPE? Number two, did the private school offer an appropriate or good education, is a better way to put that. Well, they went to a due process hearing on this question of tuition reimbursement. And the hearing officer looked at the first question, and which is, did the school district offer Drew a FAPE? And he has to answer this 2-part Rowley test. Has the state complied with the procedures of the Act, and is the resulting IEP reasonably calculated to enable the student to receive educational benefits? And then if he or she decides the school has offered a FAPE, then he decides, did the private school offer a good education? Well, the hearing officer got that far. Was the IEP reasonably calculated to enable the student to receive educational benefits? And the hearing officer looked at what the law was, which remember was this 10th Circuit's low standard, and decided, yeah, they maybe didn't do the best job, but they did provide some degree of benefit. Parents then appealed to the federal district court, went to the federal district court, a fellow named, judge named Louis Babcock, and he took the case and he affirmed the hearing officer's decision that the Douglas County Public School District had provided a free, appropriate public education, although even he said it wasn't the best education, but it was good enough to meet the standard of the 10th Circuit. Then it was appealed to the U.S. Circuit Court of Appeals, which is right under the Supreme Court. And they're the ones who came up with this standard, which was the educational benefit mandated by the IDEA must merely be more than de minimis. That was the term they used, merely be more than de minimis. That term was from a previous circuit court decision, 10th Circuit. Actually, the major opinion, or the opinion in the case was written by Neil Gorsuch, who is now in the Supreme Court. And the term he used was merely be more than de minimis. Well, people found that pretty upsetting. And Drew's parents really found it upsetting because they said, essentially you're saying because the school district in the 4 years Drew was there did a little more than nothing, that should be okay. That's okay under your standard. So they appealed to the Supreme Court. Well, when you appeal to the Supreme Court, what the attorneys do is essentially ask a question or two of the Supreme Court. And they put the question to the court like this. They said, what is the level of educational benefit that children with disabilities must meet, or schools must confer on children with disabilities in order to provide them with a FAPE under the Individuals with Disabilities Education Act? So in other words, they're saying, we know about the 2-part Rowley test. Procedures, we're not concerned about that. We just want to know what the heck you mean what do you mean by educational benefit? What is the educational standard? And they wrote a really long and very interesting brief where they said, well, there's all these circuits that say it's meaningful benefit, and there's others like the 10th say it's low benefit. What, Supreme Court, please, we need some guidance here. What is this, the standard? And to the surprise of many, the Supreme Court took the case. Well, as you know, the Supreme Court doesn't hear many cases. Maybe 80 out of what, 50,000 or probably 80,000 that get referred to them every year or petitioned to them. They don't hear many cases, but they decided to hear this, which automatically makes it pretty momentous. They bought the hearing officer or the attorney's reasoning that because you have some saying meaningful and some saying good or even trivial or even less than trivial, you've got to settle the issue. So they took the case, and on oral arguments were made on January 11th, 2017. There were only 8 justices at the time, which meant if it became a 4-4 decision, it would be like the decision never happened. The 10th Circuit, with their merely more than de minimis, would prevail. So these were kind of considered the conservative members. These were considered the more progressive members. So it could have been a 4-4 decision. Now, actually, I had to be in Washington. I lived, quite a way away from Washington in Columbia, South Carolina. But I had to be in Washington on January 12th. So I thought, boy, a chance to hear a Supreme Court case. This doesn't come on special ed. This has only come along 12 times in the last, since 1975. I've got to take advantage of this. So I called Delta and I changed to January 10th, got there a day early. And when you want to go in to hear a Supreme Court decision, even important people like Matt, he couldn't call and make a reservation. You have to go and wait. In fact, there's a little line that forms right down by Justice Breyer's tie where you wait. And some decisions, people wait literally for days. Most decisions they don't, but you can imagine gun control or abortion are real hot issues. There will be people who actually have a tent and will stay out there. So I got there the court opens at 10 o'clock. I got there at 4:45 in a cold rain. It was about 32 degrees, and I was the third in line. So this is great. There's no way I won't get in because only 50 get in. They also have another line where you can go in 10 minutes, but if you want to hear the whole case, you have to be there, and you have to be among the first 50. And so I lined up. I was third, so I thought this is a cinch. Talked to the people ahead of me, and they didn't really know much about the case. So I thought, well, why? I wonder why they're here. Well, it turns out in Columbia, South Carolina, we don't have them, but they were professional line standers. What they do is when there's a congressional hearing or Supreme Court that somebody really wants to get into, you can pay $30 or $40 an hour to get a professional line stander to take your place in line. So the first 2 people were professional line standers, but I got in. Number 3, and my friend who's also presenting, David Bateman, got in 21. He was about 5 people away from me, but it was raining so hard that we didn't realize we were there. But we got to hear the oral arguments, and they were fascinating. And by the way, if you're ever in Washington, go down to the basement of the Supreme Court. They have a Supreme Court museum. If you're interested in that kind of stuff, it's fascinating. But it was a very interesting decision to listen to. And right away it became Chief Justice Roberts in a past life, I guess he was an educational attorney, so he understands educational issues very well. And as we listened to the case after David and I were talking, we think, what do you think it'll be? Well, we thought it would be Roberts would go over to this side and it would be 5-3, or Kennedy probably go there maybe 6-2. Well, lo and behold, it was a unanimous decision. It was an 8-0 decision. And the Supreme Court found for Andrew F. That did what's something called vacating and remanding, where they vacated the decision of the 10th Circuit saying, your decision is no longer good, but here you go. Now you can decide it again. That's called remanding. And so they heard the case again, and they kicked it back to the lower court, to Justice Babcock, and said, you decide. But here's what they said. You remember the big question they asked was, what exactly do you mean by educational benefit? And during the oral arguments, Justice Sotomayor, who is always interesting to listen to, kind of put the whole matter as saying it's really a choice of words. We've got to find better words to define what we mean when we say educational benefit. And Justice Breyer said that clearly the idea requires more, but she agreed with then Sotomayor, we have to find the right words. And these are the words they found. To meet its substantive obligation under the idea, a school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Well, when this decision was announced, people were very excited by it. And, I remember the lead attorney for COPA said something like, this is a game changer. This changes the nature of special education. Progress appropriate is different than educational benefit. Progress kind of implies that movement forward. So we now had a decision that seemed to be very positive in terms of special education, actually providing educational benefit. I mean, in terms of progress to youngsters. And one of the most interesting, I think, lines from Chief Justice Roberts' decision was this: the IEP must aim to enable the child to make progress. After all, the essential obligation or function of IEP is to set out a plan for pursuing academic and functional advancement. And whatever may be said of it, he went on to write, this is a lot more than the merely de minimis standard. When we're talking about progress, we expect that in a court or hearing officers may reasonably ask for and receive a cogent and responsive explanation of why your IEP was to enable the student to make progress appropriate in light of their circumstances. So that was 2017. That's where things get left off, with essentially a new two-part test. So the two-part test I had to apply to a FAPE case prior to 16. I had to apply one to a case I did last month. It looked a lot different because now I had a new second part. So in essence, the Supreme Court didn't overturn Rowley, it clarified it. It just clarified the educational benefit standard. So the first question is there: has the state complied with the procedures set forth in the law? That is the procedural part. Then the part that Julie Weatherly would call the content part, that's the part that comes from Andrew. Is the resulting IEP reasonably calculated to enable the student to make progress appropriate in light of the student's circumstances? Now, got to keep up with this. Okay, so that's our new standard. Now, as a hearing officer, I had to, as a state review officer, when I had a FAPE case last month, I had to apply this new test. It still has Rowley in there. It still has, but it has Andrew in the second part. Now, I should say, too, that one of the things the Supreme Court said in the Andrew case is, well, no, it's still not about maximizing educational progress of a student. It's still not really about equal opportunity. So in that sense, it kind of struck a middle ground between what people were hoping is it would mean actual progress and that or maximal progress, and what the Rowley court said of some benefit, and then was interpreted as de minimis. So it kind of struck a middle ground. But it did make changes. Now, so the important thing to understand about this decision is it doesn't change the procedural requirements. You still have to follow the procedures, although Congress in 2004 actually said procedures are only a violation of IDEA if they violate a student's substantive rights to a FAPE, kind of making the substantive part of the test a little more important, and we'll talk more about that later. But here's a few things, quotes I want to show you, both from people at this conference. Julie Weatherly, who did our first keynote today, important IDEA provisions, and she talks about important IDEA provisions and the process and content standard for determining FAPE. She refers to the second part of this test as the content. Think of it as the content requirements. It really has to do with, if a child is going to make progress, it really has more to do with the content. What is in that IEP? What are the goals? What are the services? And Perry Zerkel, who is also, he's not here presenting, but presenting virtually, says the substantive side focuses on the adequacy of the IEP in terms of its likely or actual results. He wrote this in an article in 2017. So we have to remember that essentially the idea is not a guarantee of success. What Perry wrote is that it must be likely to lead to progress, or the actual results show progress. That meets that second standard, or the substantive, the second part of the Rowley test. Now, what was the final chapter of Andrew? Well, like I said, the 10th Circuit kicked it back to Lewis Babcock in the Federal District Court of Columbia, or of Colorado in 2018. He overturned his previous decision, ruling in favor of Andrew F., saying that Andrew's IEP was not appropriately ambitious because it did not give Andrew the chance to meet challenging objectives. And interestingly, Babcock wrote a lot of his decision was devoted to the behavioral issues, that they never addressed his problem behavior in an appropriate manner. So what happened after 7 years of litigation is the Douglas County School District paid $1.3 million from their general fund to settle this case. Now, of course, all school districts have insurance, but they had to pay $1.3 million to even hit the, I guess, to hit their deductible, or I don't know what it was, but they paid 1.3, which was very similar to the amount Florence County 4, a little district in South Carolina, paid for a Supreme Court decision. So they paid $1.1 million out of the general fund. So that's a pretty big deal. And if we think of this, all that could have been prevented at the IEP table if they had just, kind of done what Julie Weatherly talks about in terms of the 4 C's, excuse me. Now, also a very interesting document I'd refer you to, and this is on the, I think it's on the jump drive and will be online, so don't have to copy that long URL down. But the U.S. Department of Education, approximately, well, it was almost a year. No, it was almost a year after the original decision, issued a document called Questions and Answers, Q&A on U.S. Supreme Court decision in Andrew F. And what they did is they reviewed the case and then presented 21 questions. What does this case mean? What does it mean for placement? What does it mean for this? What does it mean for that? And then they answered it. Now, U.S. Department of Education document is not like the law, but it is a real, it can be used in court cases, and it's a very interesting document. I would suggest you all go to it. You could actually just go to Google and say U.S. Department of Education Andrew F. Q&A, and you'll get to it. It's a PDF, really interesting and really good. Now, they interpreted one way, and then another way to think about what does Andrew mean, 4 years after it was decided. There have been a number of circuit court decisions that have looked at this case, and I'm not going to talk about many. I'm going to talk about one with a little detail, but the Second Circuit heard a couple. I mean, these were FAPE cases in which they specifically cited Andrew and what this decision means. So this is filtering back down to the to the circuit courts, and there's been tons of district court decisions. Actually, I found 4, I think it was 2 Indiana U.S. district court decisions on FAPE citing Andrew, and 2 state decisions, which are due process at the state level, citing Andrew. The Fourth Circuit, Fifth Circuit had done 3 of them, the Eighth Circuit, and the Ninth Circuit. That's a very interesting case, MCV, Antelope Valley Union High School District. I'll talk a little about that, what this case means to to those of us in special education. But I'm just going to go through these real briefly. I don't think I included a slide about this, but the Fourth Circuit said, we were wrong. We got it wrong. Andrew says it's more than we thought educational benefit was. So they actually have upped their standard to meet the Andrew standard, as they must. Now, the other circuits, like the Third Circuit, in this decision, which already had a meaningful benefit standard, and the Fifth Circuit, they essentially said, well, it doesn't do anything to us because we already had a high circuit. But the 10th Circuit and the 4th Circuit said, oh, we got it wrong. Or the 10th Circuit at district court level, hasn't heard at circuit court level, they said, we got it wrong. We didn't essentially, in FAPE cases, require enough because the Supreme Court says progress appropriate in light of a child's circumstances. Now, just to go through a couple of these cases real quickly, the one out of the Second Circuit, which is real interesting in a way because the United States, the 4th ranking officer in the United States Department of Justice is a person called the Solicitor General. It's a woman that was just appointed in the Biden administration, and I don't remember who it was in the Trump administration, but many people refer to that in Washington speak, call the Solicitor General the 10th Supreme Court Justice. There's only 9 justices, but they often ask the Solicitor General, please write us the write us the federal government's position on this law. In fact, in the Andrew case, they went to the Solicitor General in the Obama administration and said, we would like you to submit a brief on the U.S. federal government's position on Andrew. And very interesting. You can go online and get this, and I think I put the reference later on, where he essentially told the Supreme Court, yeah, I think you need to take this case. And oftentimes, that's why the Supreme Court will take a case, because the Solicitor General says, go ahead, yes, go ahead and take it. The Solicitor General pointed out the same thing Andrew's parents did, that there's a difference between the circuits. Some say meaningful, some say low. You've got to settle this deal. The funny thing about the Solicitor General is he said the Second Circuit had a low standard. They said, no, we had a high standard all along. So they said prior decisions are consistent. So if you're in the Second Circuit, who knows? But they did admit, in this case, one of the interesting things they talked about, because ever since the Andrew decision was passed, there's been this idea there's a procedural and substantive split in the idea of regulations, that there's procedures we have to follow, and then there's what Julie calls the content standards we have to follow. And in 2004, Congress said a hearing officer may only rule that a procedural mistake violated a child's right to FAPE if that compromised their substantive standard or compromised their education in some way, or denied the parents the right to be involved in their child's education. Which an article Perry Zirkel wrote 2 years ago, he said that may be the kind of the ultimate procedural safeguard. You have to involve parents. And as I know, I can tell you as being an expert witness, it seems that both sides, that the parent attorney will generally use something that attorneys call the spaghetti strategy in trying to convince the school district or the hearing officer or the judge that the school district violated child's FAPE, and that is they will find as many things as they can. and throw it up against the wall like spaghetti, and whatever sticks, that's what they're going to go with. If they convince a court that you constructively excluded parents by predetermining a decision or just not having them involved, it's very likely you're going to lose on that procedural ground, because that is the paramount of the procedural safeguards. But this court said, and this court decided in favor of the school district in this case, and I think they decided rightly, but they did say that multiple procedural violations may deny a FAPE even when procedural violations taken by themselves do not deny FAPE if there's so many of them that they effectively result in the parents not being involved. So we have to really keep track of those procedural violations. Now, another interesting decision out of the Third Circuit. Remember, this circuit already used the meaningful benefit standard. What they said is, a student's IEP must aim for the progress that is appropriate given each child's unique makeup. And they were fine with progress because they said that is exactly what we've been saying all along. This case, interestingly enough, did involve the repetition of goals from one year to the other. But the court said, in this case, that was not a violation of FAPE because the school district collected data and tried to make changes, but the child was not making progress. And they had data that they could show that that they had made good faith efforts. They recognized the child was not making growth and tried to do something about it. But because they're different, what they had done really didn't make a difference. They kept the same goals. And the court said, well, that's okay. You tried. You made those good faith efforts. And you have to remember, the IEP is not a guarantee the child is going to meet those goals. The IEP is essentially a guarantee that we're going to make good faith efforts to provide a free, appropriate public education. More about that later. This is interesting because at the Fifth Circuit, that's Texas and Louisiana and Mississippi, they had the higher standard already, so they essentially used their own old standard. So if you lived in one of those states, this is the standard that a hearing officer or a judge would use to determine if a FAPE IEP was reasonably calculated to provide a FAPE. The IEP must be individualized based on the student's assessment performance, administered in the least restrictive environment, implemented in a coordinated and collaborative manner, and this is interesting, allow a student to gain positive academic and non-academic benefits. So they said that doesn't really, the Andrew decision is not a lot different. Now, here's the one I want to spend a little more time talking about, and that is MCV Antelope Valley Union High School District, 9th Circuit, 2017. This decision came down 5 days after Andrew. And the circuit court had that decision before Andrew, but waited to see. They knew the Supreme Court was going to decide, so they decided, well, we'll just wait and see what happens, and we will react accordingly. And of course, what they did is they had to accept the Andrew decision, progress appropriate, but I think they went on in some interesting ways to tell us things as school district personnel that we really should be thinking about. One of the things they said is, in enacting the idea, Congress was, they cited Rowley in a couple of cases, but they said this, and this is interesting. In enacting the idea, Congress was as concerned with parental participation in the enforcement of the IEP as it was in its formation. Now that's interesting because, you know, we're all always taught that we involve parents in the process of writing the IEP, but the Ninth Circuit is saying, but we have to also inform them of their progress, which we know we need to be doing. And so essentially by informing them, parents, of a child's progress, we're essentially keeping them involved in the enforcement of the idea, because they could use that information in enforcing. Parents could use that. So that's why we have to keep parents involved about the data we're collecting on a child's progress. This case involved a blind child who had a lot of supports he needed. And one of the things the school district did, why, I don't know. But the child they decided in the IEP meeting that they wrote in the IEP and decided in the IEP meeting that they would provide 240 minutes of, they called it visual integration training or whatever it was. It was, the services they would provide. They said 240 minutes a month. Well, what they had meant to write in the IEP is 240 minutes a week. And they didn't call the parents and tell them they made a mistake. What they did is they erased the old one, or deleted a month, and put in week. And the parents didn't actually find that out until the hearing, that they had changed the IEP unilaterally, the minutes. And in the IEP, they had put the child will receive no assistive technology services. And then they provided the services. It was really a mess. But, and actually the school, Julie this morning was talking about how this one court really said one attorney's brief didn't pass the laugh test. They just clobbered the attorney for the school district because they said essentially you were deceptive to the parent, which is not a good thing for courts to think. Because that, again, is the paramount procedural safeguard. So parent participation doesn't end when the parents sign, should be signed, not side, the IEP. Parents must be able to use the IEP to monitor and enforce the services that their child is to receive. So it's very important that as the IEP goes, and we know Article 7 talks about, and the idea about monitoring a child's progress, and they don't say you have to do this, but they give the suggestion that it's often as a general ed child gets report cards. We have to be reporting that to parents. That is extremely important because that does what the Ninth Circuit called involving them in the enforcement of the IEP. Very interesting. A couple other very interesting things out of that case, and I'll talk about that in a minute. First off, one of the things I was talking about today is case law is sufficient tests of the effects that Andrew is having on school districts, and I would say not necessarily. Case law is important. Due process hearings are also important because the hearing officer, they're making decisions that may eventually go into the courts. And here's why it may not be a sufficient test. One is parent advocacy groups are being armed in the specifics of the Andrew decision. Go to understood.org. They have the thing called the Andrew Toolkit, which parent advocates literally are to take into an IEP meeting that quotes the Andrew decision about various aspects. So they said if the school district says this, cite Andrew here. So parents are really understanding this. Parent advocates really understand how important this decision is. Also, the burden of proof. Back in many years ago in a case called Schaffer v. Weiss, I think it was 2005, the Supreme Court said the party bringing the lawsuit, which has always been the case in most circuits, bringing the lawsuit has the burden of persuasion. That is, they have to prove to the court that their facts are on their side. Well, Supreme Court kind of turned that on its head when it said that a due process hearing officer can ask and reasonably expect a cogent and responsive explanation for how do you believe your IEP would result in progress. So in other words, the hearing officer could ask that. And attorneys always ask that. How do you know? And what Rowley said is, school district, you better be able to come up with a good answer for why your IEP was reasonably calculated to enable a child to make progress. Also, I was just at a school district attorney conference in Wisconsin and one in Pennsylvania. School district attorneys were saying, we're settling more quickly. If a school district doesn't have data to show progress, or they don't collect it, or they just don't keep it, we're going to very likely consider telling the school district, you maybe just should settle this case, because you don't have much to stand on if you have to show that your IEP was reasonably calculated to enable a student to make educational progress. Now, I showed this in the last session I did, but Kathleen Mayfed was attorney with Reed and Smith in Virginia. They exclusively represent school districts. Kathleen pretty much did FAPE cases. She also was a consultant with LRP. I heard her say this at the Tri-State Special Ed Law Conference in 2015, 2 years before Andrew, as a school district attorney. And so I went to her and I asked her about it, and she said, absolutely. She said, when I have a school district with a FAPE case, the first thing I go to a teacher is to go to a teacher and say, give me information on your student's progress. If the teacher doesn't have data, I strongly consider advising the school district to settle. That was 2 years before Andrew. So if we put that together with what I heard in Wisconsin and Pennsylvania, it may be that this case is leading school district attorneys to settle more quickly in the absence of data. So if you don't have measurable goals, you don't have data, that really counts against you. Now, what the lessons of Andrew F. are, I think, is one, you begin with a well-defined understanding of all the needs of the students and a thorough assessment of all the students' needs. Barbara Bateman, kind of the grande dame of special ed law, says the present level statement is a foundation. If the foundation's bad, the rest of the IEP is likely going to be bad too. And she points out, and there are a number of cases where school districts have lost in FAPE cases just because they had done an inappropriate assessment or not carried the assessment in the present levels. Second, you need to write measurable annual goals that are truly measurable, and you have to measure them, and you have to collect data on those measurements. And one of the things I always I talked about last session, is one of the things you want to do in writing your goals is make sure your goals are something that can fit into the teacher's daily activities. You don't want to make goals that use ways to monitor progress that are so difficult that teachers might do them, they might not do them. They need to be user-friendly, they need to be efficient. You know, I remember going through classes where they taught you momentary time sampling to measure student behavior. Teachers aren't going to do that. They just don't have that kind of time. So when you write your measurable goals, make sure there's something that teachers can fit into their daily activities. Same with the services. When you write the services, Julie this morning was talking about Doe v. Withers, a case where this IEP for a student contained accommodations that were to be done in the general ed classroom, which involved, and I thought it was reading tests to students. The teacher said, I know what the IEP says, I'm just not going to do it. And you know what happened? The teacher wound up paying like a $25,000 fine because that violated Section 1983 of the Federal Criminal Code, which, you know, usually attorneys for parents will go up to the school district and try to get tuition reimbursement, things like that. But if you have teachers, and this is really true in a high school, that are not implementing the program modifications that you talk about, you need to make certain that they are actually implementing, as they said, and you need to collect information like implementation logs or something to make sure. There was just a case I read on Dale, I think. So, oh, they're just pointing to, hoping no one gets killed in here. Like implementation, I just read a case where a school district had written Check and Connect. Do you know, anybody know what that is? It's a system where with kids with behavior problems, you meet with Check in, check out. That's what it's called, check in, check out. You meet with them in the beginning of the day, counselor meets with them, talk about, get them all set for the day. You're going to have a good day. These are the rules. Remember to follow them. Gives them a sheet to take to the teachers. And at the end of every class, the teacher is supposed to check everything off. At the end of the day, the kid checks out with the counselor or whoever again. Well, they wrote that into the IEP, but they forgot to do it. Or maybe, as they said, they did it, but they just didn't keep any evidence. Well, as Julie says, document, document, document. They didn't have it. Court said, didn't happen as far as we're concerned. So really take that very seriously about collecting data, keeping implementation logs. About services too. Make sure they're implemented as written. And then measure. We've got to make certain we monitor student progress toward their goals. Remember, the idea requires that not only do we write measurable goals, Article 7.2, not only do we write measurable goals, but we also include in the IEP how we're going to measure a student's progress toward his or her goals. Have to do that. That's, progress monitoring. We've got to do formative assessment or formative monitoring toward our goals to see if a child is going to be making those goals. If they're not going to be making them, what do? You meet to find out what changes you can make in the child's instruction to meet those goals. So it's not just that you measure goals, you also have to react to the data you get. So in terms of lessons from post-Andrew hearings, I want to talk real quickly about this, and I've already told you my background is as a due process hearing officer, now as more of a state review officer. Hearings don't set precedents, but they're the first line of defense. That's where a lot of the action that you'll eventually see percolating up to the courts and even to the Supreme Court that starts at the due process hearing level. So it's a good idea to pay attention to those. Hearings are expensive. They can cost $10,000 in South Carolina to $50,000, and that's kind of, they're all over the place, but they can even be more expensive. So they're very expensive. Emotionally, they're exhausting for parents. Usually the end of any constructive relationship between parents. Remedies, hearing officers can do tuition reimbursement. They can do comp ed. So they have some very important tasks when they do hearings. Now, in terms of procedural requirements, that, remember, is kind of the how and when of the idea. That's what the Rowley test was about. So compliance with those procedural requirements is absolutely essential to ensuring that every child receives a FAPE. And that was from the 2017 Antelope Valley decision. And especially procedural violations that interfere with parental participation in the IEP formulation process undermine the very essence of IDEA. That was from Antelope. Actually, they lifted it from an earlier decision they made called Amanda J. Procedural violations that interfere with parental progress undermine the very essence of the idea. So that's a very important thing. We understand. Parents have to be involved. Number one, I talked about the spaghetti strategy. And one thing, attorneys, if they can convince a hearing officer or a judge that the school district predetermined the decision, you will lose. So that, because essentially by using predetermining placement or programming, you're essentially cutting the parents out of the process. So some examples of procedurals. Child fine obligations, Julie had a ton of cases, didn't go over them. There's always cases on child fine obligations. That is, a school district has to affirmatively look for kids. I've got to have a case right now where the school district, this kid with emotional disabilities, alleged emotional disabilities, he was hospitalized, he tried to kill himself twice. I mean, it was obvious as the nose on your face, but the school didn't do anything. My prediction is they will lose a child fine case. So we had some very important child fine obligations. Prior written notice, that's a big deal. Prior written notice, it hasn't changed since 1975, but school districts routinely, in fact, our attorney for the State Department of Education in South Carolina used to do an annual thing at our big, we used to have an administrative conference, and it'd always end with her talking about this violations for the year before. The violation investigations that the state does, you all know what that is, right? She'd always start out by saying, but not every year. One year I remember she started out by saying, folks, I'm going to sing out of the same songbook I've been singing out of for the last 10 years. You've got to do prior written notice. Because schools, for some reason, South Carolina schools have a hard time. And that's a very important thing, because prior written notice gives parents a chance to say no. If you don't provide that notice, either when you do something or you choose not to do something, you're not involving the parent. Parental involvement, obviously very important. All those, the members we have to have on the IEP team, very important procedures, especially if, say, it's a math thing and we have to have the math teacher there and they don't come. That can be a real big deal. That has been an issue in a couple cases. Placement is a procedural requirement, assessment and identification. Procedural errors are important, but remember, we talked about this before. In 2004, Congress said they don't always, minor things won't cause problems, major things will. Major things are if you impede a student's right to a FAPE, cause the deprivation of educational benefits, or significantly impede the parents' rights to participate. So these are the kind of things we often see in procedural violations, that I see, I should say. Substantive requirements represent the what, or what Julie called the content standards of the IEP. That stresses the importance of the IEP being reasonably calculated to enable the child to make progress in light of his or her circumstances. Substantive violations I've been seeing in the hearings I've been reviewing, in the cases I've been in, failing to collect data. That's a bad one. As Kathleen Mayford said, I strongly consider advising the school district just write a check for tuition reimbursement, but just settle the case. Because if you don't have any proof that what you've done is, if you don't have that data, that's a real killer. Failure to write measurable goals. And we talked for a whole hour about this, or 90 minutes, but measurable goals I can count on one hand the number of really well-formatted measurable goals I've seen in these cases since 2015. And teachers, it's not that they don't want to write measurable goals, it's sometimes that they don't know. So that's why it's important you listen to Matt when he tells your schools about writing measurable end goals. Extraordinarily important. And then the last thing I want to say is internally consistent IEPs. If you have a need, you have to address it in the goals. You have to address, or at least, or I should say, you have to address all needs in the service statements. Many of them you're going to address in the goals, and you're going to have to measure. If you don't do that, like my two cases ago, I had a case where this poor kid had these needs, a lot of needs in math, no goals, no services. Internally consistent IEP does not provide FAPE. Your IEPs has to be internally consistent. Here's the last I wanted to talk about. Implementation requirements. This is where MC V. Antelope Valley School District was really important. Implementation requirements, which were often seen as a procedure, means, and Julie talked about this morning, and there's some cases about this, that when you write an IEP, you implement it as written. You don't, we're not going to really, we don't need to do that. No, whatever you agree upon, you have to do. Now, there are material errors and errors that are not very serious, like, if you make certain errors, like if the certain teacher wasn't there for a review and they had an excuse and they weren't there and they weren't involved anyway, that might not be a big deal. But if it's a material thing, like kind of like forgetting to measure goals, or actually collecting data, or not providing a service you said you'd provide, that's a material error. that will cause a school district to lose. There are cases now where school districts, even with the best procedurally enacted IEPs, good substantive content, that are losing because they're not implementing. So really check that. Make sure implementation goes. And I would say to middle school and high school, this is very important, because you have program modifications in your IEP that your general ed teachers need to be doing. Make certain they do them, and have some kind of logs that show they do. After an IEP is written, and appropriate placement determined, we must provide the student with the services that we'd said we'd provide. And I wanted to say this is from MC Antelope. I was in CEC 2 years ago in Portland. I don't know if any of you were. My wife and I were walking around town, and here we come across the United States Court of Appeals for the Ninth Circuit. This is where the MC case was heard, so I had to take a picture of it. The judges wrote in this decision, the IEP, like a contract, embodies a binding commitment and provides notice to both parties as to what services will be provided to a student. The IEP is not like a contract. It's not a guarantee of success. It is a contract in that it is saying, here's what we're going to do. Now you have to do it. Once that agreed upon, once it's agreed upon in the IEP meeting, just do it. Make certain all the aspects of the IEP are implemented. I wouldn't be concerned with, well, is it material or is it not material? Just do it, what the IEP says. I listed a couple FAPE recommendations. Understand and avoid procedural problems, especially parental involvement. They, in and of themselves, could cause a school district to lose a FAPE case. When you develop a student's IEP, make certain your assessments are relevant and recent, that have good information, and put that, all the needs, in the present levels of academic achievement and functional performance. Ensure IEP annual goals are appropriate, ambitious, and measurable. Of course, measurable is the one we've been talking about. Andrew also talked about ambitious. Every child, according to the Andrew decision, has must have an opportunity to meet challenging and ambitious goals and objectives. Many cases have been decided against school districts. One very important case out of South Carolina eventually wound up Supreme Court, called Carter v. Florence. The reason it went to the Supreme Court, it had to do with a different issue, but the reason they lost a FAPE case at the district court level, and it went on to the circuit court and eventually the Supreme Court, is the judge said the goals weren't ambitious. He said they were so unambitious that they rendered the IEP inadequate at inception. So err on the side of ambition when you write your IEP goals. You want to be reasonable, but you want to be ambitious, not ambitious. It's the unambitious goals are more likely to get you in trouble. Remember that the old business acronym, SMART goals? That actually comes out of business. Specific, measurable, and I would change the A and the R to ambitious but reasonable and time-bound. So make your goals ambitious. And then, of course, continuously monitor and measure a child's progress toward their annual goals. Maintain specific data, because the cases I've been in recently, that's one of the first things when we talk about the spaghetti strategy a parental advocate will go after, and that is, where's your data? Where's your explanation that this goal is reasonably calculated to enable the student to receive benefit? And then if your data show that a child is not making growth, you have to make a change. And the last thing is, I put a couple in here, you can read them on your own, just things we've gone through, but I wanted to go to the last one especially. Remember this, implementation is, in fact, Perry Zerkel wrote an article, he believes this is the next wave of FAPE cases are going to be about implementation. Because courts have been saying, procedurally correct, substantively good, but not implemented, you lose. So we want to remember that. I also listed a number of references on the cases. If you have any questions about other reference, and there's other great things like the Progress Center, OSEP, U.S. Department has a Progress Center, National Center on Intensive Intervention. email me. I put my email at the beginning of this. Be happy to answer any questions or queries you might have. And that's all I was going to talk about. Sorry, I meant to leave 10 minutes for questions, but I'll be here if you have any questions, so thank you very much. Okay.